Welcome, and thank you for joining us for today's webinar on cybersecurity and privacy, risks and obligations for your practice, proudly presented by PracticeHub and Avant Law. In the spirit of reconciliation, PracticeHub acknowledges the traditional custodians of country throughout Australia and their connections to land, sea, and community. We pay our respect to their elders, past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples today. Thank you for joining us for the latest PracticeHub webinar. We have a great panel with us this afternoon who will be addressing some of the many questions which have come through during registration, which we thank you for. On our panel this afternoon, we have Justin Fung, who heads up commercial and corporate in the Avant Law team. He has over 15 years experience advising in commercial, corporate, risk, compliance, governance, regulatory enforcement, and dispute resolution. We also have Anna Maria Gibb, the co-creator of My Practice Manual, now PracticeHub. Anna Maria has a background in practice management and qualifications in business and adult education. I will now hand over to you, Anna Maria.
Excellent. Thank you, Katrina, and welcome everyone who is joining us today. Thank you very much for giving up your time. Fantastic topic with a fantastic speaker. As you can see from the overview here, we are going to get through quite a lot of areas around cybersecurity today. So fundamentals of privacy principles and your general obligations, cybersecurity and cyber resilience, the regulatory implications of privacy breaches, the processes for managing a notifiable data breach, the ever topical email usage in medical practices. And finally, I'll be talking about how PracticeHub can help you manage your cybersecurity risks with some of the policies, procedures, and compliance processes in the system. So without further ado, let me hand over to Justin.
Thanks so much, Anna Maria. Hi, everyone. It's great to be here. Look, it's a very topical issue that we're dealing with at the moment. As many of you would have heard, Optus had a massive data leak recently, and no doubt there's going to be a lot of heat in this particular space, and a lot of legislative reform is no doubt on the way as well. But it just shows that cybersecurity is a real and present issue, and that cyber risks are real and present threats that I guess practices and businesses across the country really need to grapple with. So a bit of background about myself. As mentioned before, I've been working as a lawyer for a number of years, initially in a global firm, Herbert Smith Freehills, and then subsequently in-house for a business called Helios Limited before taking up a general counsel role in a sort of allied health business, and then coming over to Avant Law more recently. But I guess a bit of background about myself in terms of when I first had my first brush with privacy law. It was probably about 12 years ago. I was advising a client on employment law matter. There was an employee who was basically involved in a very significant data breach. And at the time, I kind of thought, look, privacy law is just too complicated for me. I just ended up engaging a special counsel in the business, in the firm, to help us out. But then I just kind of realized over time that, look, as technology has changed, as the world has changed, that I think everyone needs to have some sort of basic understanding of how privacy law works, whether you're the employee who's dealing with a customer or whether you're an executive or a director. I think having an appropriate level of knowledge is very important. And I appreciate that lots of you here on this webinar today will come from different size practices. Some will be smaller, some will be bigger, some will be in between. So what I'm trying to really do here is just give us some kind of fundamental basic structures to kind of think through. And then obviously, during the Q&A part of the seminar, hopefully we can ask some more specific questions that might be relevant to your scope of operations. Okay, privacy law. Look, it can be a little bit complicated at times, but it can be also pretty simple as well. And I have a former colleague who's, as part of her spare time, she's made a bit of a hobby to summarize key areas of law in 25 words or less. I found this really, really helpful when I get my head into a bit of a muddle. Having something like this really just kind of centers and focuses my attention on what the key issues are. And look, this is privacy law in 25 words or less. Look, if you handle information that can identify someone, just make sure you collect, store, use, and share it safely and properly. So there's a level of simplicity to that, but if you can remember that, I think that it will really allow you to kind of work through the complexity and the detail of it as you kind of look at some of the key regulations that we'll be turning to in a moment. Okay, so how does the Privacy Act work? Who does it apply to? So basically, persons who collect, deal with, or disclose personal information are subject to the Privacy Act at the Commonwealth level. And the key, I guess, core of the Privacy Act is captured in what's called the Australian Privacy Principles. And there are 13 of them that we'll run through shortly. Personal information is, what is it? It's any information or opinion about an identified individual or an individual who is reasonably identifiable. And I guess in our particular space, in the medical space, there's a subset of information, personal information, that is relevant to us as well. It's what's called sensitive information. And we'll go through exactly what sensitive information involves and what sort of, I guess, regulation arises in connection with that. But basically, there is a little bit more regulation that applies to sensitive information. It can cover anything from health information to information about someone's race, ethnicity, religious beliefs, or sexual orientation. Before we kind of move on to the 13 privacy principles, there are certain obligations that apply at the state level as well that you should be mindful of. I don't think you need to be across the detail of it. And if you're seeking advice from us, we can always kind of go through it in more detail depending on what jurisdiction you're in. But there's state-specific legislation when it comes to the regulation of health information in New South Wales, Victoria, and the ACT. And for those of you who are running a general practice as well, and you're connected with the My Health record system, there are the My Health records rule that you need to be aware of. And basically it requires you to have a record and security access policy as well. But I think Anna Maria can kind of take us through that in a bit more detail later when she does the PracticeHub presentation. Okay, let's move on to some of the general obligations, and in particular the 13 privacy principles that underpin the Privacy Act. And look, I'll go through these relatively quickly, but I just want to give you a flavour of each of the principles. And obviously, if there's any questions that arise during the Q&A, please feel free to kind of throw them up and we can see we've got some time to address them. Now, the first principle relates to open and transparent management of personal information. And in a nutshell, it requires that there are practices, procedures, and systems implemented to comply with the Australian privacy principles and to deal with any inquiries or complaints. So at the most basic level, you really need to have an up-to-date privacy policy, which captures all the key issues in terms of how the entity collects information, how information can be accessed and corrected, more importantly, how individuals can sort of make a complaint if they think that something's occurred that's untoward. And they're also generally important to have provisions dealing with, I guess, disclosure overseas as well. That's the first principle. And really, it's a sort of a catch-all principle. The second is anonymity and pseudonymity. Individuals have to have the option of not identifying themselves or being able to use a pseudonym, unless, of course, that's impractical. So it's something to be mindful of. It's not often that sort of issue will come up in practice, because I think most people are happy to kind of share their information, personal information, provided that they're confident that there are systems in place to protect that. But something to be aware of is that you do have an obligation to provide for that if it's reasonably practicable. The third relates to collection of solicited personal information. And of particular relevance when it comes to health information is that with respect to health information or sensitive information, the individual must consent to the collection of that information. It can't just be a sort of an implied consent. It's got to be something more than that. So we would generally recommend that there are kind of written policies in place or collection notices, which we'll turn to in a bit more detail, under which the individual consents to the collection of that information. And more importantly, that information has to be reasonably necessary for one or more of the collecting entities' functions or activities. So you can't just collect the information without a particular purpose and without sort of connection to, I guess, the particular operations or functions of your business. That won't be a problem for most of you. For most of you, your centers will be, collecting personal information, health information for the purposes of facilitating or delivering healthcare services to individuals. So generally not an issue, but just something to watch out for, because we'll touch upon direct marketing later. It's a bit of a hot topic at the moment. A lot of practices are seeking to direct market, and there are some restrictions around direct marketing that we'll turn to shortly. The fourth principle deals with unsolicited personal information. Now, something to be aware of is that if your business is collecting personal information and it didn't solicit that information and wouldn't have otherwise collected that information in accordance with the previous principle number 3, then you have an obligation to either destroy or to de-identify that information, provided it's reasonably practical to do that and provided it doesn't cut across any other kind of law enforcement or other legal obligations that you might have. Moving on to the fifth principle, notification and collection of personal information. This principle is what sort of underpins the privacy collection notices or the privacy collection statements, which should accompany any collection of personal or health information. And so basically it says that, collecting entities at the time or before the time of collection have to have a notice which, in summary, identifies the contact details of the relevant entity. So it's quite important that you identify the relevant legal entity that's in fact collecting the information, including if the entity is part of if you're in a bigger, I guess, corporate structure, the specific entity that's collecting the information, because the Privacy Act does say that there are restrictions between sharing personal information between entities, even within the same corporate group. So for example, I was in a business previously that had probably about 4 or 5 different business divisions, it wasn't sufficient to simply, I guess, have a single notice to kind of share information across all the business divisions. There needed to be, I guess, each of the business operations needed to have their own separate privacy collection statement to kind of show exactly what the information was being collected for and how it was being used in accordance with the functions within that business division. So something to work out for if you're in a bigger corporate group. And I guess what that privacy collection statement also needs to do is it needs to explain to the individual what the consequences are if some or all of the information isn't provided to the collecting entity. So that's something to keep in mind as well. Moving on to principle number 6, the use and disclosure of personal information. This is where we talk about, this principle talks about the primary purpose and the secondary purpose as to why the information is being collected. And basically it says that the individual has to consent. And this is where I guess in some cases implied consent might be legitimate, but the individual either way needs to have consented to the use and disclosure for the primary purpose for which the information was collected. Now, there is scope to utilize and to collect information for a secondary purpose, but that secondary purpose has to be directly related to the primary purpose. So for example, if you're in a medical center, obviously you're collecting information to facilitate delivery of health services. That's one thing. A secondary purpose could be, for example, utilizing that information for billing purposes and to ensure that billing is done correctly. That's an example of what a secondary purpose is. And you can see how in that case, the secondary purpose and the primary purpose, they're both, I guess, connected and related in that particular context. There are exceptions to when information can be used not for a primary purpose or not for a secondary purpose, which is connected to the primary purpose. Those are what are called permitted health situations. So for example, if an individual is at risk and that information is required urgently to be disclosed, for example, to law enforcement or in another sort of health context, then there's scope to kind of, I guess, work outside of the requirements of the relevant privacy principle, number 6 in this case. So sometimes, subpoenas will be issued to medical centers, search warrants may be also served. And in that case, there's scope to basically rely on those exceptions to disclose personal information in breach, so to speak, of the Privacy Act, provided that one of those exceptions applies. Now, moving on to privacy principle number 7, direct marketing. As you can see, that's a bit of a hot topic at the moment. A lot of businesses, they've collected information many, many years before. They've now decided that as their businesses are expanding, they would like to direct market to their patient base or customer base using that information that was collected many years before. Now, when it comes to health information, which is a type of sensitive information, there are restrictions, and the restrictions are that you basically can't direct market using health information unless consent has been provided. And look, it's quite a strict principle, and it's very difficult because I know that businesses are very keen to be able to say, look, we're actually just helping our patient base, right? We're just letting them know that we've got services that will be available to them, that will assist them, but you do need to be very, very careful. There need to be appropriate written consents that are in place before you can direct market. Otherwise, you could be in breach of privacy principle number 7. Now, moving on to number 8, cross-border disclosure of personal information, probably a bit less relevant for practices in Australia, but just something to note is that a lot of hosting platforms are now, I guess, having provisions in their contract which allow them to kind of move data overseas from country to country, or to have people overseas access, I guess, the platform or access the data. So especially if you're using third-party vendors such as, Amazon Web Services will usually have those sort of provisions. So it's something to kind of watch out for. Just make sure you have in your privacy policy and you've considered whether your operations needs to cover off on that point. But I think most privacy policies will address that point, but it's just something to kind of keep in mind. Privacy principle number 9, adoption and use of and disclosure of government-related identifiers. I guess APP entities can't adopt government-related identifiers of individuals as its own identifier unless it's otherwise exempted under a relevant law or regulation. So just something to keep in mind. I don't intend to kind of speak too much detail on that particular point. Privacy principle number 10. So the quality of personal information. So the collecting entity has to take reasonable steps, and the term reasonable steps arises a lot in the Privacy Act. So that's where I think, there's a little bit of room to move, and it'll really depend on the size of your operations. But it's privacy principle number 10 says that the APP entity must take reasonable steps to ensure that personal information which it collects, uses, or discloses is accurate or up to date and complete. So you've got to have mechanisms in place to ensure that the information that you're collecting is actually legitimate and verifiable information. It doesn't mean that you kind of need to have all the bells and whistles. It doesn't mean that you need to have someone calling up every individual and confirming that information is accurate, but you've got to have a system in place at the time of collection to ensure that you're reasonably satisfied that this information is bona fide and it's not completely false or illegitimate. And then finally, the security of personal information, pretty basic, but the collecting entities have to take reasonable steps to protect personal information from misuse, interference, and loss, and also unauthorized access and modification or disclosure. And from time to time, if someone requests that their information be deleted, then there's got to be a mechanism in place to destroy or permanently de-identify that information if it's no longer needed. And then moving on to the last two, privacy principle number 12, access to personal information. Entities must give individuals access to the personal information which they hold, unless, and there's a couple of exceptions, they pose, the request poses a serious threat to life, health and safety of the individual, or the public health and safety. So, for example, one situation that I would see very often was that from time to time, there'd be a request from a patient to release their, consultation notes, for example, with a psychiatrist or a GP. But then the psychiatrist would notify the business to say, look, in this circumstance, I wouldn't clinically recommend that these notes be released because it could actually lead to adverse consequences to the individual. And, obviously that's something that needs to be assessed on a case-by-case basis, but it is something to watch out for. It can arise. And if the treating GP or the treating specialist or psychiatrist says, in this case, my clinical opinion is that the information should not be released to the individual, then there's scope to rely on that particular exception in privacy principle number 12. And then the correction of personal information, privacy principle number 13. Again, the PB entity needs to take reasonable steps to correct any personal information that it becomes aware of that's inaccurate, out of date, incomplete, or irrelevant. So those are the 13 privacy principles, very high level. I know I've run through them very quickly. There may be questions from some of you, but before we kind of move on to the next section, the other thing to kind of note is that the Privacy Act now has, the notifiable data breach scheme, which we'll touch upon in more detail. But basically, if there is a data breach, if there is non-compliance with these particular principles in certain respects, then there will be an obligation on the collecting entity to make a notifiable data breach to the Office of the Australian Information and Privacy Commissioner. So again, we'll go through that in more detail in terms of some sort of the parameters that relate to that particular scheme. Cybersecurity and practices, and no room for oversight, ? Okay, now cybersecurity, as we've all seen recently, remains a pivotal area, given that personal and sensitive information is now predominantly stored electronically. And, as you can see there, the World Economic Forum has stated that cyber risk has been recognized as a most immediate and financially material sustainability risk that organizations face. And no doubt there's been an increased amount of regulation that's appeared in this particular space. And obviously the Optus case just shows that it's a case on point. And so what we're seeing is the Australian Securities and Investment Commission, so ASIC, is starting to take a really keen interest when it comes to enforcement in this space. And it's recently warned directors that a failure to adequately address cybersecurity risk could result in a breach of directors' duties. And there was a recent case, I think it was handed down in July in the Federal Court of Australia, where a business in the financial services sector was found to have breached its license obligations after failing to adequately manage its cybersecurity risk. It was ordered to pay $750,000 towards ASIC's costs. So not a small amount at all. It wasn't a big business either, but basically it's really a shot across the bow to let practice owners and managers and business owners and directors know that you've got to remain proactive when it comes to understanding where your business is at in terms of cybersecurity. Now, it does raise a few questions for businesses, and we'll go through, some of these questions in a bit more detail. But at the highest level, I think basic things that need to be considered include, you and your practices, have you got a cybersecurity risk management system that's in place for allowing, management to have appropriate visibility and to comply with your Privacy Act obligations? Is there testing and verifying of the effectiveness of those systems from time to time? Are you sure that there are practices in place to ensure that information is stored securely and is protected from third-party infiltration? Can you and your business promptly identify data breaches, actual or potential, from time to time? And have you got, appropriate vendors engaged to allow you to ensure that you've got a level of comfort that cybersecurity risk management systems are working as they should? So, those are sort of the high level issues to consider. And in the next section, we'll look at, some of the principles of good practice that ASIC has recently handed down when it comes to cyber resilience. And it's great to see that ASIC is, although they are kind of stepping up their enforcement measures, they're also giving guidance to businesses in terms of, look, hey, if you want to kind of increase your cyber resilience, these are some of the key things to think about. And so we'll run through the 11 items of the toolkit when it comes to cyber resilience that ASIC has provided the businesses. And I think that we should be able to provide this as a link, setting out some more of the detail, because I realized that I've just kind of listed in this slide the 11 items of the toolkit. But firstly, starting from the top, board engagement. Questions to ask is, is your senior leadership team or the board taking ownership of cybersecurity, ensuring that the strategy and the risk management systems are reviewed from time to time? Is the board viewing cyber resilience as a critical management tool for understanding risk status and the importance of investing in those particular systems? The senior leadership team and the board educated in the language of cyber resilience and potential threats? And are there assurance processes in place focused on end-to-end business processes, looking at critical business operations, technology operations, and testing all those as a whole? That's something that I think is very keen for businesses to develop. Now, moving on from the board, I guess more kind of general governance structures are important as well. So does the company or the business have a tailored set of governance practices to ensure that governance is responsive to any sort of cyber security issues that arise from time to time? Are there policies and procedures and frameworks in place that are documented, strategies as well, and rules and procedures which can assist the business and guide the business I think through any kind of cybersecurity risks? That's something that needs to be considered as well. So the third item is cyber risk management. Are there risk management tools and automation that can integrate many sources of risk, including, I guess, collaboration with government agencies? So things to think about in your business are, depending on your size, do you need to establish some sort of specialist function to deal with cybersecurity or cyber resilience? For organizations, usually you might see like a type of risk committee that's dedicated to this. Depending on your size of your organization, you might not need that, but you might need someone who's a point person or a couple of people who are point people that can really kind of have this on their agenda and be revisiting it from time to time as may be appropriate. Depending on the size of your organization, are you relying on third-party service providers and partners with the specific expertise to be able to support you in that process? That's something to consider as well. The fourth item is third-party risk management. So you might have third-party partners and IT vendors that are in place to help you, but you have a further external service provider which can undertake periodic audits or assurance testing on those particular arrangements. That's something that, especially if you're a bigger business or if you've got any significant contracts. I was in a business where there were a number of significant government contracts that were in place, and having like an external auditor was very important in that particular case to ensure that we got the assurance from an audit perspective when it came to, I guess, third-party risk management. The fifth item is collaboration and information sharing. Are there confidential information sharing arrangements with financial institutions, security agencies, and law enforcement that you might have? And I think that probably applies to much bigger organizations, probably much less so if you're a smaller practice. Moving to number 6, asset management is something that ASIC has identified as being important in the toolkit. Is there a centralized management system to manage asset inventories of hardware, software, and data, which is both internal and external to the organization? So for example, is there visibility on critical assets and how to manage, I guess, software versions or any security patches that might need to be updated from time to time? Number 7 is, I think it's probably sometimes understated from time to time, but when it comes to cyber awareness and training, are there company-wide programs and strategies developed to ensure that cyber awareness and education of staff is front of mind? Is there continuous development of knowledge and awareness of staff implemented to enable them to really pick out where there could be a potential breach, or there could be phishing activity or malicious cyber activity that could be at play? And I think that's really, really important, because ultimately staff, the frontline staff, are usually the people who are first to pick up on any suspicious activity. So making sure that staff are trained appropriately and updated in that training from time to time is important. Is there sort of appropriate random testing of staff to ensure that there is effectiveness in the actual awareness programs that are being trained? They're being trained in is important as well. Number 8 relates to protective measures and controls. A question that ASIC has raised businesses' consideration is, has the company implemented strategies to mitigate cybersecurity incidents? For example, is there encryption of data in transit from electronic communications? Is there filtering and monitoring of outbound emails? So, a number of platforms, for example, Outlook will allow you to kind of plugins to do that, but does your business have those sort of things in place? And is there sort of highly restricted access to USB ports and computer equipment to minimize the risk of data leakage and unauthorized files being kind of brought into the system or taken out of the system? That's something to think through as well. Number 9, detection systems and processes. Does the company have company-wide continuous monitoring systems, which allows it to kind of pick up any suspicious activity? Are there data analytics that could be utilized to enable the company to integrate, I guess, source of threats and associated risks into a single view to understand the landscape that they're dealing with? Again, probably something for bigger businesses, but if you are the medium size or the larger size business, probably something to think about. And then the last 2, I guess, response planning. Is there scenario planning for the types of incidents that might arise? And businesses will generally have, I guess, ransomware attack responses that will be documented in their policies, but that's something that you want to be thinking about as well. And then finally, recovery planning. Has a business actively determined how it's going to notify customers in the event of a data breach? And is there a well-defined communication plan to manage stakeholders and public relations? And as some of you would have read in the paper recently, Optus, as it appears from media reports, struggled with that as well. And you can see that for a business that's that big, it's not a simple question. It's something that really needs to be looked at from time to time and reassessed. Some of the regulatory implications of, I guess, breaches of cybersecurity. The Office of the Australian Information Commissioner is responsible for enforcement, and it can take a number of steps to investigate breaches of the Privacy Act. It can obviously initiate an investigation. It can, I guess, seek enforceable undertakings from businesses. It can also bring enforcement proceedings in relation to those undertakings or to seek a determination. From time to time, it can seek an injunction if it thinks that there's a practice or activity that needs to be stopped straight away, and it can also apply for various civil penalties as well. Now, at the moment, a breach of the APP, so I won't go into this in too much detail, but in short, if there's a breach of the Australian privacy principles, there can be civil penalties of up to $2.2 million for a body corporate or $444,000 for individuals. And there have been businesses, as some of you are aware, that have been prosecuted. Facebook, I think, a couple of years ago, and more recently, Google as well, in the way that it used, I guess, customer data in a way which was misleading and deceptive. So that's something to be mindful of as well. But I guess where we're seeing things go is that the government is starting to kind of, I guess, increase, just given the number of security breaches that have arisen, are starting to increase the penalties. So there's a proposal to amend the Privacy Act to increase, I guess, penalties up to the grade of 10 million or 3 times the value of the benefit obtained through the misconduct, where there are businesses purposely breaching the Privacy Act to kind of make a profit, and also 10% of the company's annual turnover as well. So there definitely is, I guess, something that we need to kind of watch out for, is that the price of breaching the Privacy Act and the cost of it is starting to increase businesses. Okay, that's it from my perspective on that section. We'll move on to notifiable data breaches, which I touched upon before. So what do you do in the event of a breach? I mean, firstly, these are kind of high level principles, and obviously you probably need to kind of consider this in more detail. Avant laws here to kind of assist with navigating you through that should this occur. Hopefully it doesn't arise in your business, but if it does, we can be here to kind of step you through the process. But in terms of I guess, a high level overview of the process, obviously taking immediate action to investigate what's caused a breach and to take steps to prevent further breach from occurring is the first step. And then I think the next thing is probably like a legal question. Consider whether the breach is in fact a notifiable data breach under the notifiable data breach scheme, because not every breach will be a breach that falls within a notifiable range. So a data breach essentially occurs when there is unauthorized access or unauthorized disclosure of personal information or loss of information that an organizer or agency holds, firstly. And then the key thing is determining whether it's likely, that disclosure is likely to result in serious harm to one or more individuals. And I guess the third criteria is the organization hasn't otherwise been able to prevent the likely risk of serious harm via remedial action. So basically, there's been a leak, it's likely to cause serious harm, and the business hasn't kind of been able to kind of take steps to mitigate against that. In that case, then you have a notifiable obligation to kind of report that to the OAIC. If you're a bigger business that falls within, I guess, there's a piece of legislation, I won't go into detail. It's called the Security of Critical Infrastructure Act, which Optus would have been subject to. Basically, it adds an additional layer of compliance and notification obligations when it comes to notifying the government of privacy breaches if you fall within that. And some hospitals will fall within that. So if you're a practice or if you're a hospital that falls within that, then you will have specific kind of obligations that apply in that space. But I imagine for most kind of smaller medical centers, at the moment, they don't fall within the relevant asset class that applies to. But again, I would keep an eye on that. That could change in the future. I guess do a poll. Did you want to kind of run us through the poll?
Yeah, absolutely. You take a breath. You've been plowing through so much information. It's so relevant, so interesting. All right. So the question is, does your data breach policy identify who are the members of the data breach response team? So if you think there's been a data breach or there has been, who is going to be notified? Who is your in-house team that's going to be managing the response? So it's a simple yes or no question. So Justin, just while we're waiting for that, one of the things that I was thinking that was interesting was you mentioned about the direct marketing privacy principle. And I think it's a really good, like there'd be many instances of, you have access to all this information. So if we have information about particular health conditions, can you market services or products relating to that? If you haven't explicitly asked for consent to receiving that kind of material, how would that work?
Yeah, that's a really, really good question. And it was a question that sort of arose in my previous role all the time. Like you said, there is so much valuable information that's collected from individuals. And a lot of that information, in terms of direct marketing to them, we're not really sort of like, if you're a medical practitioner, it's not like you're spruiking some sort of, necessarily an alternative medicine product. You might just be wanting to let them know that, hey, look, we've got additional health services that will be of benefit to you that we think that you'd like to know about. And look, there are some businesses that take a kind of a pretty bolshy view, and they say, well, we're providing a beneficial health service to patients. We're prepared in this particular case to say that this is the primary purpose for which the information was collected is arguably connected with a secondary purpose, which is marketing these specific health products that are connected with why the patient came into the practice in the first place. So there's scope to kind of, I guess, look at that particular line of argument. But at the same time, Australian Privacy Principle 7 is pretty clear that when it comes to using an individual's health information, sensitive information, you have to have obtained consent. And my general, I guess, view on this is that you need to have a look at the scope of the consent which the individual provided at the start. Is it kind of broad enough to potentially allow for direct marketing, or was it at the time that consent was written or provided, it was so narrow that it's going to be hard to sort of really direct market in this particular circumstance? So really you need to consider it on a case-by-case basis. Like I said, some practices will take the risk and take a bit more of a robust view on it, on what APP number 7 means, but it's something you probably need to take legal advice on or get some sort of practical guidance on when that issue comes up.
Terrific. So good news, Justin, 72% of the respondents, they do know who the members of their data breach response team are. So I think that's good news. For those of you that don't, it's either maybe you don't know who they are or maybe you haven't created a response team. So I suspect it would be ideal to have that in place pretty quickly.
Okay. All right. How to mitigate a breach of privacy. So basically, look, I think we've covered most of this already, but just to recap, I think at the highest level, the ASIC principles that we looked through before, and again, I think we'll try to kind of circulate some more detailed resources on that. That's probably a really good checklist of practical things to really think through at the kind of strategic level. But I guess at the more kind of basic operational level, just ensuring that you've got a privacy policy that's up to date and complies with your obligations under the APP, ensure that that's updated and reviewed from time to time. But not just having a privacy policy that's sitting there. Make sure that your managers and key people within your business are across exactly what's in that privacy policy. And you've got systems in place which are consistent with the privacy policy. What I've seen from time to time is that businesses will have a great looking privacy policy, but the actual operations on the ground just don't line up with what's going on there. And that delta can obviously cause issues when something goes wrong or if a regulator knocks on the door. That's the first thing. I think the second takeaway is, look, undertake a thorough review of your data processing and storage procedures when it comes to your personal information, and just ensure that any third parties who may provide personal information are also required to comply with those obligations through the contractual documentation that you have with them. It's a bit of an oversight. Sometimes I see businesses will have these provisions in place with their IT providers, but they won't have specific, I guess, clauses dealing with supporting the business where there's a notifiable data breach and actually doing everything reasonably practical to assist in any notification. That's something that you probably need to have a look at in your contracts to ensure that you've got that particular mechanism in place. And I guess the third thing I want to mention is just having an internal facing policy. I guess everyone knows exactly what happens when there is, in fact, a privacy breach. So the last thing you want is either one for the person who's identified it to do nothing, which is obviously not ideal, or for the person that's identified it just to notify the wrong people. And so it doesn't sort of get escalated up the chain. It takes too long to get to the relevant decision makers who can actually take action. So just making sure you have an internal facing policy that really guides each of the relevant stakeholders through that. That's pretty important. Again, that's the high level. And move on to the next section when we're going to be looking at the guidance in terms of using emails in general practice. And in particular, we'll be looking at, I guess, the RACGP's guidance. Now, the RACGP, as I understand, most of you on the call will be probably connected with a GP practice. So this will probably be quite relevant to you. But the RACGP, if you're probably aware, has identified a number of risks which arise for practices which communicate health information with patients, health organizations, and third parties via email. And there's a number of reasons for this. I guess, at the practical level, emails can just be sent to the wrong recipient. The use of unsecured or unencrypted email creates a risk if the email is intercepted. Emails are often used, as most of you will know, on, I guess, portable devices, smartphones, tablets, laptops, which are easily stolen and can be, I guess, hacked into when they've been stolen. Emails can be forwarded or changed without knowledge or consent. And, I'm sure you've seen that from time to time where an email's been forwarded to you and it's potentially been tampered with. And it creates, I guess, a misleading sense of what the communication in fact was. And as I mentioned before, emails is vulnerable to interception. So in order to kind of address and to mitigate this risk, the RACGP has come up with, I guess, some helpful guidance that it recommends to practices. And we'll go through that in a bit more detail, but at the high level, I guess, having things like documented policies and resources in relation to the use of emails. And I understand that, the PracticeHub platform provides for that, which is great. Ensuring that patient consent's obtained and recorded prior to email communication is important as well. So again, privacy law is all about giving the individual control over their information, how it's used, how it's disclosed, how it's transmitted. So having that consent, I think, is quite important. Having a system where you can verify email addresses, and again, that will vary from practice to practice, depending on your size. You need to kind of work out a way which is operationally viable for you to be able to verify email addresses. And then lastly, I think having emails that are sent with password protection or using encryption software via a secure website is something that I think probably bigger practices need to have in place. Having, I guess, a risk assessment profile of where your business sits is, I think, particularly helpful, and the RACGP has provided a view of that. I guess, again, looking at that particular diagram, where we probably want to avoid is the high risk area when it comes to use of email in general practice. But at the same time, I don't think that the no risk area is really practicable at all. So I think where practices, will really be navigating, you as a practice manager or business owner will be navigating through, will be, where does my business sit in terms of the low risk to the medium risk band? Do we have documents in place where we're recording consent? Are email communications undertaken with or without password encryption or protections? I've seen bigger businesses where they've decided that, password encryption is not particularly practicable. It just slows the operations down. Usually it's a business where it's high volume. There's lots and lots of people coming through, sitting in the waiting room. It's a bigger practice. It's just not practical in the circumstances, but they've built in other sort of practices in place to kind of reduce the risk of emails being intercepted or being seen by, I guess, third parties that really shouldn't be seeing them. So, I mean, that's something that your business, really needs to consider. And again, Avant Law can provide you with guidance, practical guidance on that if you want to have a chat with us about that. But ultimately, it's kind of taking a pragmatic lens and kind of coming with a risk-based assessment of how email should or shouldn't be used in the business. I've seen other businesses which have, they'll use password protection when it comes to electronic communications, but also I've seen situations where, a password is left on a post-it note on a board somewhere, or, I've heard that, passwords are basically shared via email because the doctor doesn't want to sort of enter the password into the system. It's much easier if he or she just hands it to the practice manager or the 2IC or even the nurse or a number of nurses just to make it easier for themselves. Again, that's something, not a practice that I would recommend. It does occur from time to time, and it's something that I guess you need to kind of consider and just make sure that you're assessing the risk that's associated with that if that's happening in your practice. I think that's it from me for the time being, Anna Maria.
So I think we'll go through, we've had some questions come through, so thank you for that. In the meantime, we have another poll question for you. So just out of interest, what are you doing when it comes to emailing patients? Do you have written policies? Do you document patient consent? Option 3 is you do both of those things. Or the final one there, basically you don't email patients, which I think from the previous slide is probably the no risk, but probably somewhat impractical in this day and age. But it'll be interesting to see, because I do know some practices prefer not to do that. Justin, one of the things that I think question or comment that came through, and I suspect a few people think that, is they're a small practice, and I think some of your ASIC checklist talked about a board and you mentioned committees and governance. In a small practice, you're not going to have the number of people. What's your thought on that? Where do you?
Yeah, absolutely. I mean, those ASIC kind of guidelines are really trying to cover the field when it comes to big organizations. As I alluded to, if you're a small organization, having a cyber risk committee, it's just not practicable at all, and it's just not relevant. The reality is, in a smaller practice, you have an operations person that will wear a number of hats, but it's just making sure that particular person is across and does have visibility on, I guess, cyber resilience and cyber strategy mechanisms that are at play, and also making sure that they have a direct, line of communication to the practice owner, or if it's a small board of directors, the board of directors in that particular business. I think that's the key issue. Governance there's no one size fits all when it comes to governance. It really is something that's evolving. I've seen businesses that are very large and yet they kind of run with a governance mindset that is they've decided, look, we're a sort of dynamic, agile business. We're pushing the growth areas. We can't afford to sort of have governance processes that weigh us down. And so they need to be agile. And so they kind of remove, I guess, certain government mechanisms in order to kind of move quickly and to kind of allow, I guess, the managing director or the directors or the senior leadership team to kind of be able to act very quickly on things. Whereas big organizations will want to have those layers of governance, will want to have the risk committees in place that are meeting from time to time, are discussing emerging risks, emerging issues, coming up with reports, reporting them to the executive risk committee, which then goes to the board. Again, that's just not practicable if you're a smaller practice, but it's important to have at least one point person that is across, I guess, this particular area.
Yeah. And I guess, even a small practice, somebody is the director, somebody is, ultimately responsible. Correct. And so they do need to be across this, don't they? Because they will ultimately be the one responsible or accountable if things go wrong as well. All right. We have a good question. If I take notes on patients in the ICU or ED with pen and paper or an iPad to assist their thinking process, and then they destroy or delete it, do they need consent for this? I think I know the answer, but I'll let you answer this one.
Yeah, so basically if they've taken a handwritten note and the patient hasn't specifically consented to the taking of handwritten notes, is that the question?
Yes, particularly in a setting like in a hospital, so in ICU or ED.
Yeah, I think that there's probably a couple of views on this point. From the practitioner's perspective, they have to take, as a matter of law, they need to take clinical notes, right? To kind of record, I guess, the clinical interactions that have arisen. And I think that my view is that those notes should be retained, especially if there is some sort of adverse clinical result that arises at a later date. But I guess one of the questions is, has there been a specific collection of personal information? Arguably, yes, there has. And if consent hasn't been provided, there's an argument that those notes should be destroyed. But I think, and I probably have to consider this in more detail, but I think that there's an overarching obligation to, I guess, the health practitioner that they need to maintain the relevant notes, especially if those particular notes are key to recording, I guess, the patient's health status and could become relevant, especially if an adverse event happens in ICU. So,
all right, thank you for that. I think probably we've had questions around cloud-based software and that sort of thing. Do you think that really that comes down to basically, if you're using, it's a third-party situation, isn't it? You, I guess, need to do your due diligence that they in turn, how they manage privacy and cybersecurity. Would that be your thought on that?
That's absolutely right, Anna Maria. I think due diligence is really, really important. I mean, I've seen businesses where they haven't even done the basic desktop due diligence in terms of a third-party IT provider. So things to look out for is, do they have a particular reputation in the market? Have they been engaged in data breaches that are sort of have been reported? Depending on the size of your business, if you're a much bigger business, is there some sort of accreditation that you'd like to see? Accreditation isn't essential, but it's just something to kind of keep in mind as well. And just making sure that, look, I mean, the reality is that the movement to cloud-based software, very few practices will have on-premises. I have seen it, but very few practices will have on-premises, I guess, platforms, just because when it comes to updating, I guess, the software, it just gets expensive. Having to sort of have, I guess, IT vendors come on site as well creates additional risk. And also when it comes to just updating, I guess, the actual platform, having a cloud-based platform where security patches can be updated from time to time, I think it's just definitely the way of the future. So look, I mean, there are practices that I know that still use, I guess, physical medical records. It's kind of probably more common than most people might suspect. But look, the reality is a movement towards cloud-based software. And I think that, like you said, Anna Maria, undertaking the relevant due diligence, making sure that, I mean, what I've seen is there are sometimes big companies that when they hand you their actual contract, the contract is 2 pages long and doesn't really contain much. I think that from my perspective, that's a bit of a problem. It's okay when everything's going well, but just making sure that you have contractual arrangements in place that protect your business, especially in the case where there's been a failure of the platform or there's been a security breach, is pretty important. Because I mean, especially with Privacy Act penalties increasing or likely to increase in the near future, protecting your businesses from that perspective is probably pretty important.
Fantastic. All right. So we did get our poll results, and I'm delighted to see that, especially as I'm about to do the PracticeHub demo, I'm delighted to see that many of you have written policies regarding the use of email. So that's terrific to see. Looks like a good proportion document patient consent, and surprisingly, maybe, I'm not sure, 13% of our respondents don't use email for patients. So that's interesting to see as well. Probably before I do the demo, the other thing I probably would mention, Justin, is that RACGP document, what's it called? Using email in general practice. That is actually relevant, I think, for any type of private practice. It's just perhaps that the RACGP have the resources to develop this sort of documentation. We did have a question about telehealth. They also do have some excellent resources about telehealth and how you manage that securely as well. So for those who are interested, I'd highly recommend you have a look at the RACGP website, regardless of whether you're in general practice or not, as this content is really useful for any medical practice. Okay, so how about I go over to our demonstration? We've got a few minutes left, so probably the key things I'd like to highlight are the policies and procedures, particularly referencing the ones that link to the topic that Justin's been talking about today. So in my demonstration site here, it is in fact loaded up for, I guess, aligned with general practice standards. But again, this content is absolutely relevant to any type of practice. So we do have content relating to confidentiality, and you can see we talk about some of these things that will look very similar to the privacy principles as well, and then processes for transferring information, informing patients how to access their health information. All of that is documented in there. Some other things that we have things around the system security and responsibilities. So again, what are the things that you need to consider? We've got our firewalls, we've got system backups, confidentiality, remote access, which of course is becoming much more prevalent now than it used to be. Other types of policies, again, Justin mentioned the My Health record. So again, we have a policy that aligns with the requirements for the My Health record as well. And again, you know, many of you or some of you may have received the request to provide that policy. You're accessing the My Health record. So there's a policy in there that aligns with that. So you can see that there's a lot of good information in here. We've recently updated our email use one. And again, I think this is a really good policy. And what I like about these is that they're written in plain English, and they make it really easy for your team to understand what the requirements are regarding their behaviour and how they use these things as well. So conscious of time, those are the policies. If you'd like more information, please let us know. But the other thing, again, that we have in PracticeHub, we have an equipment register, contracts and insurance registers. And so in the equipment, I think one of the points there on that ASIC toolkit was asset management. Again, so being able to log all the information that you have about your equipment. So where is it kept, those sorts of things, so that you're keeping track of this information and you have some oversight. When it comes to things like the contracts register, if it were my practice, I'd include things like my subscriptions to any software platforms, so your antivirus, any other third-party products that you subscribe to, your contract with your IT service provider. So again, just, you know, you can attach the contract to the actual entry. But for the rest of your team, just quickly, you know, some details. You know, they come monthly, remote or on site. We have a 4-hour response time, 48 hours for non-urgent, who can authorize these call outs. That sort of information, that if you make that easily available to your team, means that these things can be addressed in a timely way. And of course, you know, we'd be remiss from Avant if we didn't mention insurance. So obviously, you know, these sort of policies and procedures are about preventing things going wrong, but also, you know, business insurance. And I know some of you, if you have a practice policy with Avant, you'd have the cyber insurance as well. But even just recording this information so that it's easily accessible. Now, it's all well and good to have the policies and procedures, but it's also important to do training, which again, I think Justin mentioned. And in the PracticeHub platform, we have a module around privacy and confidentiality. And you can see it talks about the privacy principles, communication, technology, the practice environment, because even visual and audio privacy is still very important as well, and IT security. At the end of these modules, there's a quiz to test people's knowledge. So in addition to signing off that they've read those policies, you can also test their knowledge, identify any gaps, and provide extra training where necessary. And probably the last kind of thing to mention is that in the resources section, there are a lot of links to resources, references that I think you would find very useful. Again, there's some good information about privacy basics and data breaches, there's the preventing data breaches. So really good information that you can use. If it was my practice, I'd be using some of this information in practice meetings with the staff as the basis for training and talking to staff about this information, because the training is the really critical part. All right, that has been a super quick review of the PracticeHub site. Let me just wrap up. All right, so if you're already a PracticeHub customer, please feel free to contact our support team if you'd like any more information on any of the things that I've showed you. And if you're not a PracticeHub client, you can have a look on our website where you'll see more information about the features and benefits of PracticeHub, and you can book a consultation with our team and they'll take you through. It's a one-to-one, so it'll be all about you and your practice. Please visit our website for articles and other webinar recordings, and we're available via live chat on our website as well. So once again, thank you for your time, and we look forward to seeing you next time.
Thanks so much.